esta nube negra de la incertidumbre nos abrume. En las altas esferas la justicia se hace más ciega, mientras un pueblo sediento de verdad sigue a la espera. Actos atroces se ven en estos tiempos de animales, y ese pobre niño ha sido víctima de criminales. Personas sin alma escondiendo lo que se ve claro, tratando con influencias mantenerse en el amparo de una justicia que ciega y que mira hacia el otro lado. En un caso donde las incongruencias han brillado, ¿dónde están las autoridades? ¿Qué pasa con esto? Ya van más de 50 días y nadie lo preso. Ese pobre ángel no descansará hasta que se aclare, hasta que esto se acabe y que todos los culpables paguen. No hay razones que justifiquen el morbo de esta trama, que ya salga la verdad a flote y que se acabe el drama.
Clama, por la sangre de un ángel clama, porque descubran la verdad. Está llorando una nación entera y en todas las mentes tortura la espera. Y clama, por la sangre de un ángel clama, porque descubran la verdad. Está llorando una nación entera y en todas las mentes tortura la espera.
Has received Derek Rosa's second verified motion to disqualify Carlos, which is a little confusing because one in September was also the second motion, but whatever. This was received yesterday, shortly afternoon, a motion to disqualify Carlos. That motion will be denied. Please pass down this order denying a motion, and then Madam Clerk, I need this input and see this right now. I'm here before Lana.
Yes, Your Honor.
Sit. Done. Done. Yeah.
Yes, Your Honor.
Okay.
Orders and seekers as well. Malia.
Have you did that then?
Judge, I entered the order as well. It's already visible, as you can see.
You have it at CJ's?
Yes.
It's showing at CJ's now?
Sequence 658.
Okay, good. Now we are permitted to continue the line in this case. All right.
Yeah, wait, before you move forward, may I say something?
Of course.
Good morning, by the way, again. Would the court consider staying the proceedings and rule the fact that it is our intention to file a writ or prefer DCA?
That motion will be denied.
Thank you.
Thank you for the Easter argue about it. I'm happy to hear from you, guys.
Thank you, sir. And then also before we proceed, just for logistical purposes, is it okay if Mr. Rosa gets moved a little bit closer to the middle? Maybe I could present from here. I know there's no mic here, but I could be loud enough with the court procurement just in case I need to confirm with him a little bit closer. And that's okay with the court, not our making.
No,
Thank you, sir.
that'll be denied. But do not hesitate to inform me if you need a moment to chat with your client during the time that you are presenting argument today.
Thank you.
You're welcome. All right. So, you sent an email yesterday laying out what is been filed as free trial motions. Thank you for the 3-inch binder delivered this morning, the default expiration. However, rare copies there. I wanted to check how we might start with. Mr. Bohr, how are you?
Boy, trader this morning.
Your Highness Ho. And I have this. Let's get
Commissioner, so before we get into anything substantive, I just wanted to, in an abundance of caution, let Your Honor know that the lead detective is on the Zoom.
Okay.
She had any issue with that, but he wanted to make sure he heard whatever what pretrial rulings are for trial preparation. So that's all right with Your Honor, he's on Zoom.
That'd be great. And let me also say this.
I've got about, I've got 100 people sitting in the waiting room. We have thus far only allowed in for our Zoom the lawyers and people that we knew were integrally involved in the litigation against the go forward of accused. Thank you very much. And previously, both parties had objected to a public Zoom. I don't think there can be anything that we need to discuss today, not open to the public. If there is, we can always go into the street Zoom later. But does either party have any thoughts about whether you want me to allow in people on Zoom that are not part of your litigation team or the state attorney's office?
You keep no position rule.
How about the industry?
And we don't have an opposition to the public being allowed.
Yeah. All right. I do, and I also have to caution you that if I do that, I'm going to have to close the meeting and restart it, because the only people who will be allowed to have visual would show me a visual, or chat, or be heard are going to be people that I'm allowing as co-host. That's for security purposes, because the last time we allowed chats from the public, he had threats against participants in the trial. I could do that if you want, and I would instruct, it's going to take us 5 or 10 minutes to get that done. If you want me to do it, I'm happy opens up to the public to view it as a webinar. I'll do that. Does the party have any preference as to just leaving it as it is? We're open to the public in the courtroom. That's all required under the law. If you feel it necessary for me to open it to the public on Zoom, I'm happy to do that by way of 5. But I just wanted to know whether there's any request for it today.
The state isn't making any requests for it.
I'd like it to come.
And again, Your Honor, we do not object to the public be present, mostly during personal.
Are you requesting that the Zoom be made public?
I'm not requesting it, I'm not opposing it.
Okay, will not be then. All right. Why don't we go ahead and start? I will, however, on January 5 do that. It's just a lot of monitoring on our part and then security risk at this time. All right, let's go with Marlo Scarlett, where he has a good objection. Derek versus motion preliminary. Filed November 7, 2025. I'm going to, I think maybe the easiest way for me to do this, Mr. Real, if it's okay with you, is that there's a lot of these things that I would address at a trial after hearing the evidence up to that point, which would then tell me whether it's relevant or admissible or not. And I think I'd like to identify those, and then I would like your thoughts on whether it's something that is more pressing and needs to be addressed now.
I don't have a problem with that.
Okay, let's hear what that holds. Paragraph 5 talks about the state having provided you 878 photos. With you stated these 60 could be posted as photographs. You know, these were always, traditionally when you guys looked at these during the trial to determine what issues, what photographs address relevant issues. And I think that it might be best to do that in this in that fashion with the photos. Do you have any question reason why you should have to go through the 878 photos now?
Why we should not have to go through them out? I think the best course of action, first of all, Your Honor, I agree that the court should conduct a screening course. I think obviously for relevancy, less graphic queries that could be used, duplicate phones, etc. I think that the best and most efficient course of action would be the state as a proponent of that evidence to kind of single out the ones that they are, they're going to use, and perhaps we don't even need court intervention. We don't need to spend our time going through that amount of photos from.
I imagine what we're going to do is when we come to that point in the trial, at some grade prior to that point, so that we don't waste the time as a jury, the state will present the ones that they've selected for presentation to the jury. If you have show them to you. If you have objections to them, either whether they are specifically relevant or not, and whether they might be cumulative, you'll make those objections at that time, and prior to us bringing in the jury, we'll have figured out what we have. So I'd like to reserve this until we're in trial. Let's move down now to paragraph 10.
Monday.com, the opposite of any work platform we tried in the past. We tried other work management platforms, not naming names. They all suck. Monday, total opposite. Didn't just work, it spread. And people became Monday evangelists. And you know why? Because people actually liked using it. Now, it's not a chore. It's intuitive. You don't have to force anyone. They're on board. You can really see that Monday care about their user. The user is king. You can create workflows yourselves, no IT, no admins. And that's why we love it. There's no roadblocks. Everything can just be done instantly. We have people creating workflows and showing them off around the company. They take pride in it. I know it sounds like a commercial, but honestly, I never expected it to have this much influence.
Cuando entres a Burlington, encuentras precios bajos y regalos increíbles. Eso es energía de protagonista. Porque en Burlington, las ofertas no son lo único que da alegría. En serio, con estos ahorros, ¿para qué comprar en otro lugar durante las fiestas?
Burlington marcas, rebajas.
The lay witness testimony regarding the condition of the body. I have to address that at trial because I don't know what it is that the person might be testifying to and what would be objectionable. Unless there's something that you think is going to be testified now that we need to address now.
I don't believe so, Your Honor. Nothing past what I put forth in the original motion.
Then let's go to paragraph 11, the medical examiner testimony and escape argument. That seems to me to be a bit premature because the medical examiner obviously is going to give his credentials and would be based upon that. And the examination is done as to what opinion would be relevant under the 917 murder at SEC. And this stuff on physiological, non-psychological effects, yeah, I get that. And the Honey's case does make sense with regard to the specifics there. We'll just have to see what the state wants to present. If is that okay with you?
That is, Your Honor. Just for the record, it was my understanding from the state's response that they do concede to that specific move.
Let's begin to take a look as we travel along.
And when I say that specific point, I mean the testimony regarding physiological to psychological effects.
Okay. All right. The cell phone extraction record that we're talking about.
If I may, just just to clarify the state's position, there are some physiological responses that the defendant exhibited during the course of the attack. And so to the extent that some evidence that shows physiological response tends to prove a material fact, there are some things we would like to elicit, but as to your psychological subjective experience, we agree that would not be evidence. But physiological responses to the attack, there is some evidence that she exhibited that and do a intention.
I guess you're talking about the existence of defensive wounds.
That, and also there is some evidence that the victim was aspirating, and evidence of that is depicted in some crime scene and medical examiner photos that there is aspiration.
Okay. Well,
We'll jump that river when we get to it. But I do see your point. We'll see what's relevant and what's not at that time. Moving to paragraph 14, the cell phone extraction. I guess I got to deal with that as it comes up, or to what becomes relevant, what doesn't become relevant. And that's different for a bit of that, and may have to deal with the Brian McNutt video motion that comes up later also. But I'm going to, unless there's an objection, I deal with, well, I don't know what the state wants to present by way of cell phone extraction, and when you're ready for that, I'll take a look at it. Yes, sir.
Judge, if I may, I can let the court know that the state did file a notice of its intent to introduce a summary exhibit.
Right.
The state's video forensic expert, Sergeant from the city, did prepare a summary exhibit from the defendant's cell phone extraction. And so, to the extent that the defense court would like the specific idea of where the state is heading, I think that will be best source for everyone to look at and consider.
Have you had an opportunity to review that, Mr. Eller?
I have, Your Honor, and I think you should hold off on. I agree with reserving it.
We'll address that on the week of the 5th, because some of this stuff had a screamer of it. Or lined up being that week of the jury, but I just don't want to, we say this a lot, I want to shield my jurors out in the hallway on matters that could be brought before the courts without wasting their time. So I'll go ahead and just mark this. We'll address this on the 5th, or during the 5th. That certainly makes sense. Okay. But I must say this, on paragraph 7, it says that the state was disclosed to recordings and other evidence portraying law enforcement's custodial interrogation of Derek Rosa. This evidence includes inadmissible hearsay and/or information that is unduly prejudicial or irrelevant to the elements of the charged offense. I looked at the statement the other day, and I'm wondering what y'all are referring to.
Your Honor, are you talking about the 911 call, or are you talking about the police?
17 and your...
Or 17, I'm sorry, use this, okay. Okay, I'm sorry, what's the first question?
Sure. Inadmissible hearsay and/or information that is unduly prejudicial and irrelevant to the elements of the charged offense. What were you referring to there?
Your Honor, I think that the police interview, but first of all, I don't think that we can address this until we address the motion to suppress. I don't think that the 911 call, or I don't think that the manner in which the 911 call thus far has been presented, since they are not typically admissible under business records exception to hearsay alone, I don't think that that should be addressed at this point either. But I believe where Mr. Borsch was going in his motion is the voluntariness of obviously the...
Ma'am, I'm sorry to interrupt you, but we're losing focus here. In paragraph 17 of your motion, the one that we're reviewing right now, it says the state has disclosed recordings and other evidence portraying law enforcement's custodial interrogation of Derek Rosa. I think I've looked at those. I think those are the subject of your motion to suppress that was filed May 8, 28 or something like that. We further state in paragraph 17, this evidence includes inadmissible hearsay and or information that is unduly prejudicial and irrelevant to the elements of the charged offense. What are you referring to there?
Your Honor, I'm referring to my client's statements.
Well, why would the statement of a party not be admissible under 90.803 so 18?
Because, Your Honor, I think that until we deal, again, with the motion to suppress, I don't think that the Miranda issue should have any type of feature during the trial. I think the volunteerness of it is different. It's a different analysis, but I don't think that without actually seeing how it plays out and if we could actually overcome the Deersmith objections and we could actually overcome anything. I just don't think it's proper to rule.
Man, there's three separate things you're bringing up here. First, On its face, it doesn't appear to be hearsay. Under 90.803 sub 18, it's a statement of party opponent. Okay, that makes it admissible as an admission. You're bringing up Miranda, and you're bringing up voluntariness. You will deal with the Miranda issue at the evidentiary motions on January 5. You will deal with the voluntariness at the time of trial if this statement survives the motion to suppress. But when you use the words inadmissible hearsay, that raises an evidentiary question, not a constitutional question, and that was a little confusing for me. So I think you've made it clear, or if there's something that you clarify it more, other than the 3 separate issues that are raised by this statement, let me know. But I think I have a better understanding now.
I have to ask with regard to paragraph 16, I don't have the 911 calls. And obviously the 911 calls will deal with potentially excited utterances and spontaneous statements. And of course, if it's the 911 call that can be identified as your client, that call becomes non-hearsay also under 90.803 sub 18, unless you could show us your case file which would state otherwise. It's obviously not a Crawford issue. So, but I would like you to provide me state what you want to do in it.
Judge, I believe that I didn't provide it on flash drive number 2. You should have the certified audio of the 9.1. It was in the flash drive that included the 2 recorded statements.
I'll check it again. I'll check it again.
Yeah, it should be there.
Sorry, I wasn't able to open the statements. There's some things that I don't have an ability to open.
And
That's people great.
oh, sorry. I was gonna say I'm here all week, Judge. If there's an issue, I can bring over another call.
That'd be awesome. It's just that some of the PDF documents, they haven't provided us judges with an advanced version yet. So, all right. Moving on further on page 4, the MCI express records. I think I have to hold that in advance, Ms. Riello. Is there something I need to address on that right now?
I don't think you are.
Thank you.
Judge, and I apologize that I do need to jump in here. The statement file, it's noticed that it had to rely on a custodian of record for the FCI business records. And so I took the defense's motion eliminating challenging the admissibility of those records to be a challenge that is delineated under the subsection, which was why I am asking the court to review all of the FCI records in advance and overrule their objection to the business records. It is a preliminary finding that given the fact of the offensive challenging closed records, I don't know that he basis for them challenging it, but because they would ask the court to make a preliminary finding of our court to be, because our intention is to admit that through the certified custodian.
I'm going to see if I can pull up that, and in fact, if you could do it, Ms. Morales-Gales, pull up the certification that you want to use, and I'll share a screen with you, try to take a look at it.
Yes, Judge, just give name on it.
If you can, it might be easier than me finding on the disc.
And I have it up as
well, at least that would make it easier. Let me go ahead and do a share screen. I'm sure that all of the non-readers watching this just finding this fascinating. Whatever our song is with. All right.
I'm going to send you request to share.
The on-screen sharing. Stop. Empty my stop share. You will be allowed. Here we go.
Okay. Thanks. So I'm pulling up the certification of records. The certified custodian is Esto Porches. He is affiliated with NCI Express. He's in charge of their security, as well as the person is most familiar with the way with the trucks have GPS. So SOPS, the custodian, he is the representative of PCI, and you provide us the GPS log, trip history, videos, photos, and dispatch, all of which were...
Can you stop for a second? This is This is the MCI Express record. Now, help me out, because I got a very late start on Discovery here. MCI Express is what?
MCI Express is the employer of Frank Ramos and Yero Sevilla, as well as Irina Garcia's brother, as well as another gentleman who may or may not become relevant. So, as in the case of this document, Mr. Cortez certified GPS logs, trip history, video, photos, and dispatch regarding Frank Ramos, regarding Guillermo Saldilla, and a third individual who hopefully will not necessarily be relevant, but to the extent that becomes relevant, this third gentleman as well.
What is it you intend to prove through these records?
Yes, Judge. So, and I'll stop sharing my screen. The records were provided by NCI Express to show whereabouts of Frank Ramos at the time of the murder. According to these records, Frank Ramos is indisputably in the state of Georgia at the time of the murder. There are, given the fact that there are so many different angles of the truck, there are probably hundreds of hours of video of Mr. Ramos driving up north through the state of Florida, going into the state of Georgia. Then he discovers there's a problem at the apartment. He immediately makes calls to the NCI Express dispatcher. He is frantic. He is trying to figure out what's going on. The dispatcher then has him meet up with a gentleman named Guillermo Sevilla. And the purpose of that is that Mr. Ramos had to transfer his load to Mr. Sevilla, at least temporarily. And as your Honor likely saw in videos, you were able to see on video, Mr. Ramos drive his truck up, meet with Mr. Sevilla. There is an exchange of the load, and then the GPS rep would show Mr. Ramos driving back down to a county, and then him getting out of this truck. As we know, in the Butchie was seen to try to find out more information. So
Let me stop you for a second. You've indicated he made calls to his dispatcher, frantic. Are those calls recorded?
they're all recorded, and I can provide translations of those calls to the fort.
Did he make those calls on his personal cell phone?
Yes, he did.
Do you have cell site location on the personal cell phone?
Yes, Judge, we did get the cell site location. All right. So
this is going to be more important when we come up to the motion we'll be addressing in some kind today. Dealing with your seeking to preclude evidence from the defense. But, and the transfer of the trailer that he was towing with the truck is done with Shaker Guillermo Sevilla.
Guillermo Sevilla, and he, when a truck leaves a loading area, there is a check-in report and a check-out report, basically documenting load attached to the truck, what a beep or returns.
Where was that transfer done?
Well, the actual check-in and check-out reports are done when he arrives back in Menley, which is the headquarters for NCI Express.
Right.
So he'll show basically that he returns, he now has the trailer of Mr. Sevilla, not the trailer of the Butler, because they had to exchange.
Where did they get exchange?
They went up in Jacksonville, and that's will be GDS Ripon Show as well as Southside Railroads.
Okay. All right, I'm going to return to these a little bit later. I guess the immediate question, Ms. Riello, would be, are there deficiencies in the... Put that back up on the screen for me, Mr. Boards.
Yes, sir.
And I would absolutely only review something like this now because I don't want to spend 2-3 days having to get another custodian and to redo a record. Move it all the way down to the top. Move it all the way to the top, please. I'm looking to the dispatcher never. Hold it right there. Because as you know, the provisions within the statutes which allow for certification of by a record custodian without them appearing before the court. And I see it as a time saver, unless you have some belief that these records are not the records of MCI Express.
And Your Honor, let me start by saying no. I think that MCI does keep these. First of all, we have to separate these records, right? You have to separate the trip logs from the GPS, from the videos, because the trip logs are kept and handled by MCR. The GPS logs were handled by Geotab, which is a separate company. And the videos that Your Honor has belong to Samsara, which is also a separate company.
Now, may I ask you this?
Yes, sir.
MCI Express is saying that they either major in the course of regularly conducted business activity by a person having knowledge of the matters, and that they're kept by them in the ordinary course of your business. Why would that not fit under 90.3 sub 6?
They are kept by them. I think really that the issue here comes with that they have knowledge of them, because when Mr. Cortez was deposed, we specifically said that he couldn't testify to certain things about the inner workings of that product. He keeps the logs because obviously if there's an issue or if there's a subpoena and he turns over those logs, but he can't really testify, for example, as to why there's a time difference in those videos. He can't testify as to why they're incomplete. He can't testify as to a lot of the technicalities about that evidence, and that's why I think it's important to parse it out.
Well, that witness would be available for you wish to subpoena him, correct? But I mean, the standard here is very low. Right. And determining whether these are business records or not. And you don't seem to be indicate, well, I guess what I hear from the argument is that because of some type of gap, that they're not sufficiently trustworthy under the general concepts of hearsay. But I'd need to hear something far more specific than that. As far, however, as a records custodian affidavit goes, do you have any argument that this document is not sufficient to show that the material that it describes were not made by a person having knowledge of the matters, were not kept in the regular, not kept in the force of regular conducted business activity, and were not made as a regular practice?
No further argument.
Okay. So then I will ask you this: if you have a trustworthiness argument to make, that's going to have to be factually based, and I'll ask to be provided that during January 5, during that week. Because I just don't want to have to stop a trial in the middle, shield the jury outside, and take on witnesses to do something that we could do now. All right, let me continue on. Conclusory statements for identification on page 5 of your motion. Paragraph 2125, Livy, don't give me much other than that you were having some difficulty discovery-wise. I'm assuming that this has all been completed since you completed your discovery depositions. And of course, I read your the depositions of Detective Duque, Detective Romero, Detective Firmasini. So let me go down to paragraph 26, which is the identity of the individual in the photograph is in dispute, and no witness should be permitted to comment on the identity of the person in the photograph without laying the proper predicate. Of course. Of course. Because I did notice in the depositions where the detective said, oh yeah, we saw Derek Rosa over the prone sleeping body of his mother in the baby count photo. Okay, I can't imagine the state would seek to introduce that for a detective, but I imagine there are other people who are familiar with Derek Rosa who might have sufficient familiarity to identify him in the video. But I think that's something, there was a photo rather. I think that's something we have to do if you're at a trial. Do you disagree with that, Mr. Yard?
No, Your Honor, and it was my understanding Korean State's motion that they did not directly oppose it, because that's exactly it. I mean, it's just without explaining how they concluded, what they concluded, that's where the opposition comes from.
Yeah, I think the case law is pretty clear on that. Okay, well, again, cross that hurdle when we get to it. That seems to cover all of the paragraphs in your motion filed November 7. And notice that the state's response continues on to some other things against our justice record images. You see.
Yeah, rather than say something that might be of use to his court, the 3-inch binder that we provided this morning has changed everything they up digitally, but in physical form. I like paper. I like looking at photos of paper. I don't know if Your Honor does, but that was the spirit behind it. The only thing that is new is the case law that I filed this morning in response to Mr. Boer's supplemental authority that he filed yesterday. That's the only thing that's new. Other than that,
Let's see, have you printed all out this
and I did when you're looking at a USB, or so that was the spirit behind that binder, 3-inch binder.
Okay.
Perhaps now we should pass the state's motion in a minute. Let's see.
A lot of this is stock, so I'm going to do the very same thing and tell you that whether you to rule on it now or just wait for the section of trial. Paragraph 1. I can't imagine that. Skate, you're not going to do that, are we?
Well, I'm not going to do that, but I want...
Oh, you want the defense included for discussing other specific cases where defendants were wrongfully convicted? I think that's probably appropriate. I mean,
It's just not an issue to be brought up very jury selection that up until you with following the law for a year.
obviously it depends on how our question might be phrased. So on paragraph 1, paragraph 2, paragraph 3, I mean, paragraph 2 and 3, 4, 5, 6 seem to be fairly black letter law, Mr. L. Would you disagree?
No, Judge. In fact, for expediency, 1 through 7, preliminary original issues, obviously barring new doors being open. 11, I don't see it as an issue item.
Okay, and you know, that's interesting because I had, actually 11 I wanted to talk about. I had circled for discussion with you guys paragraphs 8, 9, 11, and 12. And on paragraph 8, the state seeks to preclude you from, what you limited in cross-examination of police officer witnesses using the Hialeah Police Department manual. I'm not so sure about that. What would be the... I guess, of course, it depends on how it comes up, but why would they not be able to do that, Mr. Boers?
Well, at the end of the day, Judge, it's going to be an investigation as to whether rules follow procedure in the manual. It's going to be whether or not the juror believes the testifying officer's testimony. So whether or not they follow a particular policy or procedure in the manual doesn't go to whether or not their ability to remember and convey information based on what they saw and did. It really has no application. And that's why I did feel the motion that the defense should be limited. I think at some point it's a 403 analysis that if there's some questions, some juridic questions as to why it is they get something or didn't do something that's they're directed to do in the manual flub thing. But if it becomes a feature of every cross-examination, all we're be doing is finding out how well Hialeah followed the internal policies. That's not where this is trial.
Well, obviously, we're going to get to the question of whether they followed their policy in that particular circumstances. has to prove or disprove a specific element.
There ought to be some kind of connection.
So, how do you anticipate this might arise, Ms. Biela? I mean, what is it that you think, what shortcoming do you think is relevant, or alleged shortcoming, I don't know if there are any, but you're going to tell me, is relevant to any issue that's going to be filed in this lawsuit?
Your Honor, I don't think it's particularly relevant if, for example, Detective Erosegi is not aware of a certain policy that does not make a difference in the case. I think that if Detective Erosegi, for example, testifies that he did X, Y, or Z, or that he didn't do X, Y, or Z, and that the manual calls for something different, and if he had done what the manual calls for, then it would have made a difference in the case, then I think that the making of the difference in the actual case might become relevant versus just asking their knowledge of the manual. So
Yes, that's what I'm asking you. What specific violations of policy do you believe have been shown by discovery that you believe are going to be relevant to any issue that's going to be tried in this lawsuit? Anything, I'm asking for specifics.
You're right, we need to wait till it plays out. I mean, preliminarily, the handling of the evidence, the chain of custody.
Which evidence are you referring to?
For example, Your Honor, we did an inspection of the evidence, the initial inspection of the evidence back in November. We noticed that there were items that are not included in the property response. For example, a bra. I don't know if that bra was tested. I don't know where that bra came from. I don't know if that bra would have made a difference in this case. I do know that I have a lab report that did not test, or let me put it this way. If the perpetrator would have been a woman, the type of DNA testing that was conducted, we wouldn't know that. So I don't know how this bra, I don't know how the bra is relevant, but I do know that if there's something in property, it should be a property receipt, and I should know what was done with it.
So let me say this, let me ask this, I don't want to try the case right now, but why would a bra be relevant in this space? Was this a bra that was worn by the deceased at the time of the incident?
I should be able to ask that question. I don't know.
I'm asking the parties this question. Your 750 crime scene photos that I'm aware of that I've seen, what is it about a bra that had any relevance to this case in any fashion?
Your Honor, that's why I think that number 8 needs to be reserved, and we had to see.
It's going to be reserved, but here's the deal. I don't want to have to waste a lot of time going through this when it comes up on irrelevant matters. All right. Either party won't be. You okay with me just reserving on this at this point, Mr. Boris, Ms. Riala?
Yeah.
All right. Question number 9. The defense should be precluded. You're asking me to preclude them and limit them in opening cross-examination about internal affairs investigations.
Yeah. What is it that, now that you have done a full investigation in this case up to this point, Ms. Riello, how would this issue arise at trial?
There on number 9, well, there's 2 ways that I've seen this arise. One would be a situation where law enforcement believe that they have the right suspect and they do more further investigation. They stop looking, pretty much.
What does that have to do with an internal affairs investigation?
If Your Honor recalls, well, I've been at this court recalls, but there was an internal affairs investigation that was detonated as a result of one of the officers in Hialeah Police Department transmitting some of the ME photos to a chat that Hialeah Police Department has. The chat is part of the case file. We received the screenshots and the photos and the video. And as a result of that, the Hialeah Police Department, last time I checked, is still investigating the internal affairs. We're still investigating these officers and what happened. I don't have access to the report. I don't have access to the investigation. It's a pending investigation.
Okay. Mr. Boris, do you think there's anything there that would be relevant? If not, why not?
I used to teach. But you know, but
I can't hear Mr. Marsh.
Leon Haverfeld, let's see you.
Oh,
No. Can you speak up? Let me check something else here. 1 minute. writing.
It's better to put a bit. So I guess I can break it down to two questions. First question, is the existence of that chat that the detective sees during the investigation relevant? I can't see why it would be. It is really the investigation story and share certain information shared, but this is evidence but not a role that to an church fact. And then the second question to be the fact that on some of those images made its way to the public, how that be built or 100% theory. And I don't see any correlation there followers and opening up a fine question that is say that under 403 it just even seems EK.
Allow me to interrupt you if I could. Yeah, Boris, jump up to your position.
And at first part that does make some sense, Ms. Riel, because I don't know that the fact that the officers shared these photos amongst themselves, and that somehow they leaked into the public, I'm not sure what issue or element that proves in this case.
Now, there's a secondary thing about motive and bias, and I'll address that in a moment. But the fact that they shared the photos amongst themselves and that some of them may have been released in the public, what does that prove or disprove in this?
One thing, well, I'll start by saying that the jury will be advised of opening statements and closing statements and the fact that counsel's allowed to argue, which should not consider as evidence. In terms of what does that prove?
Not if I excluded, ma'am. Not if I tell you, you will not state that to the jury because I've made a preliminary ruling that it would not be admitted as evidence. You will not be able to say that in an opening statement. You'll make your record if you think I'm wrong, and we'll go from there. But that's why I'm asking you now. And you haven't tried a case in front of me, and we'll see when we start talking about the state's King motion. I'm now keen about keeping you from presenting what you want in defense of your client. But I do like to see at least some relevance to what we're talking about. Where's the relevance to the fact that they shared this?
Well, Your Honor, first of all, it's not just for record-keeping purposes. This was the beginning of the investigation. This is part of the case, much like a supplement the reports. That's also a way that they exchange information. I would say that it's a parallel to exchanging via WhatsApp. They're sending photos of what's happening, they're making comments about what's happening, and they're doing so with officers that have not arrived yet. I would say that by that point, they're making comments about exactly the conclusion of this case, which to them, at that early on stage, was that Derek Rosa killed his mother. That was the conclusion before that fine scene had even been released. And again, it's not just them exchanging it. I would hope that it's not just them exchanging it for the purpose of shock or glory. I think they're genuinely exchanging it as part of their investigation, much like they supplement their reports, much like they call each other on the phone, and much like they update their notes on new witnesses, new information. I don't see how I would be forbidden from asking a detective about how they store information. And that's part of how they store information. How do they share information? That's part of how they share information. How do you keep up to date before you arrive on the crime scene or what's happening at that crime scene? And that WhatsApp chat is part of it.
Well, yes, we'll get there during the trial, but obviously if it's,
Well, what's wrong then with them sharing information in that fashion? If it's part of their investigation and informing other officers of what's been found or what is believed, and after all, police may take a position or may have leads that they follow or may want you to have some sense of what occurred so that they can start collecting evidence in an appropriate fashion. All right, well, if you're going to be crossing an officer about how he conducted this investigation, that's fine. Any other, in the fact that an internal affairs investigation, But let me ask you this, have you had an opportunity to review the internal affairs investigation paperwork?
No, Your Honor, the policy to not be released while it's pending.
All right, and if it's pending, obviously,
he had an officer who was under investigation, he'll be able to ask him whether he is under investigation, because he may have a motive to shade his testimony towards the state so as to gain favor. That part of us pretty clear.
And can I just, on that, which is just a side earlier, the state is not investigating any of his officer or detectives because they noticed, right, for the internal affairs investigation for terminate ID posts, get any of the policies procedures that were not followed in relation to these of WhatsApp, but I don't think it would be fair or accurate to imply or suggest that any of these officers or detectives will be testifying for example.
That's your position, sir, and you'll have to show me some case law otherwise, because my recollection of the case law is if you're under an active investigation from the police department, that's subject to being addressed during cross-examination. So if you've got case law that states otherwise, you'll bring it to me when we get to address this. Let me continue on to paragraph
11. If this court were to rule that his constitutional rights were not violated, I think this is correct. The defense would not be able to argue a constitutional violation. He would be able to argue just that the state, if you believe the facts, supported that were not voluntary. You feel otherwise on that, Mr. Reality, because you're pleading, because I've gotten his pleading. You disagree with the fact that you would be limited to just voluntariness?
But like I said, you from the beginning, preliminarily 1 through 7, I don't have an issue with, nor 11.
Okay, very good. All right. Now, when we get down to 12,
no testimony or evidence regarding a YSTR quiz kit that state says is firm related to the crime charge.
which I guess forced me to read the April 26, 2024 DNA report here. Which item or exhibit are you referring to in there, Mr. Boers?
Yes, sure. And I think I clarify so it's immediate. The YSQ focus is not a hit to any of the evidence. It is a hit to the understand, and it is not a match for a hit implying that there is some other person who has the same DNA as defendant. Obviously, that's not possibly true. YSER is only looking at the Y traumacy for the defendant standard. And what that would do is it gets to any other member of the defendant's paternal line. So there was a YSCR hit for the defendant's standard, not any of the evidence, okay? And so that YSCR hit connected to another young man who was prosecuted. And here, because of what we know through science, it was a young man that has some paternal relationship or some genetic relationship to the defendant through the paternal line. That's all that means. So there's no connection to that YSCR hit and the evidence. There's a connection between the defendant's YSTR profile and another young man prosecuted in a totally different case. There's no relationship between that young man and this crime, and it is not the DNA match. It is the YXTR association.
What do you say about that, Ms. Riavon?
It's a lot to be said about that. So I'll start with this. Mr. Bohr saying that the person, the 2016 incident, where an individual minor at that time was arrested for sexual assault, that person has no biological connection to Derek Rosa. I know who that person is. I have since gotten a hold of that report. I know where that person's whereabouts were in 2023. There is no...
Was it over in Hialeah at 11 o'clock at night on October 12th?
Sir, I would like to reserve that for trial, but...
I'm asking you a question, ma'am.
I don't...
If you have that information, and either yes or no, I'm asking that. We're going to go through this in a couple of minutes when we get to Frank Ramos and all the rest of this.
but I'm curious. It may or may not control what my ruling is, but it certainly is something that I'm certainly allowed to ask you, and I'd like an answer to it.
If you're asking me if I know where this person was on October,
No, I'm asking you if you knew whether you have some information to believe that he was in Hialeah at 11 o'clock at night on October 12th.
I don't.
You had any reason to believe or information which would indicate that he was not?
I don't.
Have you asked him?
I have not.
Have you got his telephone records or any indication that this person who is remotely related biologically or through DNA, through some paternal link, is actually an appropriate suspect in this case?
Here, that's the point, that there is no relation. Well, that's part of the point, that there is no relation. So I think we start with CODIS, right? CODIS is a database. And I think that the first question of this analysis is the state using a CODIS in this prosecution? Okay? Because that's how the link came about.
Sure.
In March of 2025, Detective Mui supplemented his report with this hit. When I say this hit, is one page, it's actually one paragraph report. If they're on their calls, I filed a motion to compel to get more information about the report, because Derek Rosa would have been 6 years old at the time, and he wasn't the victim of the crime. So I said to myself, gee, why would his sample be hitting to a 2016 case that preliminarily it seems that he has no connection?
Wait, I'm sorry.
Yes, sir.
Because the explanation I have from Mr. Borsch is slightly different. In other words, is there a DNA sample from any of the items that were collected that lead directly to, that would be admissible in court to show that this other fellow, that was his DNA?
The items of the CR, you're asking me?
I'm asking, well, I got Mr. Borsch shake his head. First, let's start again. Mr. Borsch, what item are we talking about?
Okay, so the way that CODIS works, Judge, is that when a person who has been arrested gets a viewable standard.
That would be Mr. Rosa's DNA.
In this case, it was Mr. Rosa's, and they basically take the profile, the generate from that standard, right, the people swap, and they put it in the CODIS database. CODIS then looks to see if there's any other profile that looks like the standard. In this case, there was an individual whose YSTR, which is not incomplete DNA profile, it is only one's profile, it would be Y chromosome, and it hit to somebody in Derek Rosa's eternal line.
Okay, and so would that evidence be admissible, sufficiently scientifically reliable to be introduced in a trial for this other person charged with this crime?
Well, do you follow what I'm issues?
Here, I'm asking you, and I'll ask Ms. Riel in a minute, because what I got here is, I'm looking, try hard to get through this, but I'm looking at stuff that says like, swabs from kitchen knife handle. Watch it, matches the YSTR DNA profile obtained from the oral swabs from Derek Rosa. All right. 1 at 658 are your chances there. Is that sufficient? Would the
Essentially, all of the CODIS hit says, Judge, is that the defendant has a relative, Sarika's male line, who has been arrested. That's all the CODIS says. It doesn't say anything beyond it.
okay?
how tough? Now I'm asking you, how is it relevant?
Judge, and knowing that that person is not irrelevant of Derek Rosa, again, I think we have to go back to the database, right? And I think
Then you know he's not a. Now, when you say he's not a relative,
right.
what do you mean by that?
What I mean by that specifically is that they are not, there's no lineage connection, and they're not genetically connected, they're not biologically connected, there's all Hawaiian soil.
How they are? Excuse me, who's copying? Please don't mirror each other's. Okay, I'm asking you, how do you know? I mean, you may have asked him, you may be looking at marriage records, but you know, sometimes people spread their DNA outside the bonds of marriage or normal in a normal manner. So, but my question is this, is the fact that the S, you take a look at it, why STR code is hit here, indicating that there may be some paternal link to this fellow. Would that be admissible as evidence in the courts of Florida, sufficiently specific to put him in that dinner room at that time?
Your Honor, I believe so. I think so. Because I think that otherwise this record would not have become part of this record. I think that I should at the very least be allowed to ask the lab technician. I should be allowed to ask individuals from the lab, from FDLE. They supply, first of all, I would argue that the state is the proponent of this evidence because they supplied us with this report. I didn't go out looking for this report. Now, once this report came to light, I should be able to ask the officers, much like I'd be able to ask about other things.
I'm going to ask you, Mr. Bors, are you familiar, you're the one who's usually the proponent of DNA evidence. Since this cannot be limited to the, the wanted 1.5 decillion people type of thing, 1 in 15 billion people, how specific is it, and is there case law or anything out there which would indicate its admissibility where this fellow you have been charged in this offense?
I'm sorry, I didn't fully read you, but I'm going to speak through it. Hopefully we hear it. I think a way to answer your question, Judge, is that we know that the defendant's father shares his YSTR profile. We know that his biological brothers through his father's line have the same YSTR profile. If we were to open this up, we would then essentially have to haul in every member of the defendant's biological line to come in and say, I wasn't there. Of course, the law isn't provide for that. There's no connection between this individual and this crime whatsoever beyond the fact that he was a male relative. That's it. And so, the court has read King, and I think King is applicable here again. The city, unless there is a clear connection between some other individual and this crime, other than Derek Rosa, the defense should not be able to be accusing anybody that might have the same paternal YSTR testing. That would be outside of the lawful bias, and it would essentially they could accuse anybody on the defendant's paternal line.
Let me stop you for a second. So wouldn't this mean that if the officer were questioned about this, he would be able to say, yes, it is just, if you were to ask the Miss Riello, gee, doesn't this mean that this person could have been there committing this offense? Wouldn't the officer be able to respond by saying, yes, would be exactly the same likelihood that Derek's father was there committing the offense, or Derek's uncle was there committing the offense, or his cousin was there committing the offense? Would that be scientifically a valid answer from the detective or the crime scene analyst?
Scientifically, I believe so. If he had an uncle on his father's side, or a cousin on his father's side, or any other male lineage. Now, I think that so I would think that it would be important for us to be able to ask those questions on the DNA aspect.
So you've narrowed it down to someone who was convicted of a crime in 2015, or Derek Rosa's dad. And I don't mean Frank Ramos. This evidence basically says that the DNA that was found, I'm trying to get my head around this because, and I'm going to ask you guys for further research in a specific manner, that this YSTR that was found could belong to Derek, it could belong to his father, it could belong to someone who in some fashion shares that paternal lineage or line. Okay?
Is that what the scientific answer would be, Mr. Morse?
Yeah, and I think a fair cross would be that, you know, to the DNA analyst, explaining what YSTR is and the fact that the YSTR profile was generated from the handle of the knife, it includes the defendant, but it can also include any other member of his maternal lineage, so they cannot be excluded. I think that would be a fair cross-examination, but to bring up specific people with no clear connection to this crime within the state.
And do you think if they said, yes, we got, and for them to even say, we got codex kit, which would, what, if anybody explained what codex kit was, or even that person's DNA happened to be in a criminal database, do you think that that DNA being a criminal database would be admissible against this person if they were charged with this crime? Or the fact had been convicted of or arrested for something 8 years remotely would be admissible? But here's where I have problems with it. I mean, when evidence would see, the suggestion is a little far-fetched to me. But here's where I like it focus. There's a lot of early case law on the reliability and the admissibility of DNA. And my recollection is when it came down to G, this DNA showed that this was the one person out of 15 billion people that has this DNA. Then the courts sat up and said, yeah, that sounds pretty reliable. I think we'll let that in. That sounds like good evidence. If this is 1 in 100, 1 in 12, however many lineage people there are, I'm just not sure that the scientific reliability that had been established on DNA evidence would apply to a YSTR prototype. And I'm going to ask you guys to get a look at that sort of thing.
Sure, Jan. I could definitely provide more guidance, but just something to think about. Meanwhile, I think that the argument could also be made, and that's why I keep going back to CODIS and my understanding of CODIS. And of course, I think that if you would ask the experts of what CODIS is and how you increase different samples into CODIS, the Mayans shown use it there too. So I think that there could also be a portion of this analysis that maybe it's just error. Maybe it's a database error. And I think I should be able to ask that.
That's a different analysis here.
Not if it's, well, go ahead, John.
If you're looking at this as a suggestion that someone else's DNA was found in, I'm not sure that you have sufficient scientific basis for that. Oh, and I got to tell you, I haven't done it in a while, but my oldest daughter is a DNA a sequencer as the American G&M for this week for 10 years, so I have some insight. If you don't mind, I may ask a DNA expert about this. She didn't do forensic, but I'd like to know a little bit more about it. If you have a search, I won't. But here's my concern. Hunter, I've heard the expression. Go ahead, Mr. Morse.
Judge, my thought will be, and I think it would be helpful for me to provide you with the DNA analyst deposition. Her name is Michelle Andrade. Okay. She was fully deposed on this issue. She can explain exactly what YSTR is and why it is that what I'm saying is in fact accurate and true. So I'd like to provide that to court.
Okay. Do you disagree with that, ma'am? I'd like to look at it. I'll reserve this to a bit. Do you disagree with me, Ms. Riella, that the fact that the other individual has been convicted and sentenced would not be admissible at all in this trial?
I'd have to provide for an answer.
Oh, seriously, man? Do you think if your client had previously been convicted and sentenced of some other non-related offense, it'd be admissible in his trial?
Non-related, generally speaking, no, Your Honor.
Okay, and take a look at State versus Savino. It's a Florida Supreme Court case that says the test for this is when you're saying some other dude did it, the test for admissibility is, would it be admissible in a trial of that individual on this charge? So I'm going to ask you right now, if Mr. Rosa had been convicted of something prior to this date, that it would not fall under 404, would it be admissible in this trial,
I can't think of a way that it would be.
Me either, Mal. So as far as maybe there's other people out there in the universe who share this YSDR, what you tying it to a CODIS hit, and you tying it to a conviction or another charge, I think that's a very, very far stretch. So I just let you know, if you have case law, just to give you a crap, if you have case law that would indicate otherwise, be ready with it on January 5th. Okay? All right, that's you to clear up these issues, and thanks you for helping me understand there. I think the other two matters that you still have pending are the state's motion to admit similar fact evidence. I don't think you really need to go over the blood spatter stuff. Didn't we already address that? I'm looking at the table of contents of your Audiencia, what could you guys like to address next?
I think D is fine.
Which one?
The state's motion to preclude evidence and argument of unsupported defense theory, third-party guilt.
Okay. If you don't mind, I'm going to refer to that as the claim argument. Aim up.
But Mr. Borsch is presenting the other two motions, so I think it should, in all fairness, whatever he wants to argue next, does it have to be King? They're his motions, Your Honor, is what I'm saying. Whatever he's prepared to argue next, I'm prepared to defend.
Well, let's start with one that I think he's going to lose. Why he co-creates the notice to admit similar fact evidence pursuant to 90.404. That's and I don't know if we can lose it or not. I need to hear more about this. That's H, and that deals with, as I think I understand this, there is a video of a veteran committing suicide out on the internet, and I refer to it as the Ronnie McNutt video. As best I could discern from your emotions and the depositions you provided, was that sometime prior, September 29 or 30, there was an exchange of this video between Mr. Rosa and a minor who bears the initials of CG. Okay, I got a little confused at one point from one of the depositions as to which way the video went, from Derek to CG or CG to Derek, and of course that I was unsure of when I looked at page 106 of Carmasini, the forensic guy. Can you clarify that? The video went from whom to whom initially?
And maybe it would be helpful to give a proffer of what I believe the evidence shows.
Sure. Because that way I'll adjust what my understanding of the facts are based upon what the parties tell them. Go ahead.
So, as a proffer of what the state believes the evidence shows is that on September 29th, 2023, CG sent a video to Derek Rosa. The video was of the Ronnie McNutt suicide video. The video is extremely graphic. It is very violent. It is very blunt. And this is a suicide video that will file a second go, then is out for public information. The very next day, September 30th, 2023, the defendant, using his cell phone, sent that video of Ronnie McNutt to a group chat. The group chat is composed of friends that is from school. And so that total, for your honor, CG is not a friend from school. CG lives in a different state and is a friend of the defendant through video meetings. Okay, he shares that video on the 30th with his group of friends. He begins first by asking, "Do you want me to scare you?" And the students begin to react. He then sends the video of the suicide. The students in the chat begin to react appropriately. They are disgusted, they're horrified. And the defendant's responses to the video are not one of disgust or horror. He is, and again, the evidence supports that he's somewhat enjoying the video, and the video where he exchanged with the students, at the end of it is he writes, rest in peace, Pozo, with an emoji of a smiling face and it onto his head. A fast forward to day of the stabbing, so that's October 12th, 2025. Once again, the defendant is displaying the suicide beat. He is showing it to his girlfriend, EP. He is showing it to EP on the school bus on their way back home that afternoon. When your defendant shows it to EP, according to EP, all of this again is their sworn statement. So this is a Jubilee saying it. This isn't their sworn statements. The defendant shows it to EP. EP is very upset by the video. The defendant is laughing. He is finding the video to be funny and asks EP saying that this is funny, and she does. About a few hours later, EP, according to EP, decides to break up with the defendant because she is so shook up by the defendant's enjoyment and laughter when showing her the video. There's also, according to Sergeant Parmosini, and this in the summary exhibit provided to the defense, the defendant also shares the suicide video through Discord on the day of the attack. So on the day of the attack, he has shared the suicide video with a group on Discord, and he has shown it to his girlfriend. Okay. A few hours pass by. The defendant that begins to make a number of searches on the cell phone. Follow those searches are related to knives, stabbing, and the final search being the carotid artery. So that occurs in the afternoon leading up to the stabbing itself. Then we know, based on the digital evidence as well as some of the baby monitor ages, that the attack occurs roughly 11 p.m. That's supported by the baby monitor as well as the defendant's digital footprint in itself. About 7 minutes or so, about 7 minutes after the attack, after the murder, the defendant reaches out to CG. And again, this is all very significant. CG, the very person that sends in the Rodney McNutt video, he now was reaching out to CG, telling him, would you like to see, or, do you want to see something? Let me know what you think about what I'm sending, things of that nature. Okay, very similar, once again, to what he was doing with the Rodney McNutt video, exhibiting content, bloody content, to his friend New, in order to get the reaction. And he did this that very same day. So within less than 10 minutes after the murder, he is reaching out to CG. He then sends in a photo of his mother's body laying in a pool of blood, and then the selfie of himself with his hand covered in blood. And his expression, I would submit to the court, is he has a playful expression on his face that he is more or less showing off. And they come in sequence, one right after the other. They then have a phone call where the defendant, according to CG, these are his words, not mine. According to CG, the defendant is laughing. He thinks that what Hersch is funny. And then CG responds to their Rosa, basically, dude, you killed your mom? And CG would say that he is alternating between shock and disbelief. And remember, this is all you get to Halloween. And as I put in my notice, CG and the defendant were speaking about Halloween costumes, and the defendant wanted a scary Halloween costume. So there's a very strong connection between CG and the defendant during this short window of time. While they're on the phone, the defendant then sends more photos. One photo of the gun that he recovered from the closet, and another photo of his mother's body blue with blood. That's while they're on the phone together. CG then essentially rejects the defendant's implication to find this to be funny or a source of amusement, and the defendant reacts, and at that point he gets the pride. They do, according to CG, pray together. CG tells them that he should call 911, and then the defendant proceeds to call 911. I should also note, again, this was all related because in addition to sending these photos to CG, he sends two of the photos, first photo, the photo in mosaic selfie, and the photo of his mom at pool of blood. He sends them through Discord to around the exact same time within minutes after the murder, and the Discord chat group receives them. Only one of the students, young man, because of the star L. Only he sees both pictures. He sees the photo of Irina Garcia's body and the selfie of the defendant. He deletes the photo of the victim full of blood, but leaves up the selfie, and that other students do see the photo of the selfie that the defendant put through the Discord app. And it's the state's strong position that this, the timing, the circumstances, essentially it's the way in which the defendant was interacting with his friends is so related to the event itself because of the timing, the immediacy. All of it really shows that this extricably intertwined, and it proves why the defendant did what he did, because he immediately took the photos and sent them to his friends. All of this tightly aligned with one another and is necessary for the state to prove the full context of what occurred.
And yeah, so that's why I talk her.
That whole profit, Judge.
I got your proffer, Mr. Boris. Let me ask you this. Would it be your intent if I said that there is some relevance to the fact that CG was someone that he shared gory stuff with, and was the first person he called with gory stuff on October 12th? If I see some relevance in that, are you seeking to admit or show the Ronnie McNutt video?
Your Honor, I think is the court where it conduct a 403 balancing, and the court found that the video itself would be unfairly prejudicial. Then we would, of course, understand that the court, in an effort to protect the defendant's right to a fair trial, if the court felt that that would infringe on it, then we would accept the court excluding the suicide video itself as overly prejudicial, but ask that you're able to admit the testimony of the witnesses.
Okay, Ms. Real, I need to hear from you on this, because I got to tell you, I started looking at this in a review of I wouldn't think that I were allowed to send, but without the actual video being introduced, which is second-sided prejudicial, which it's just way too graphic and disturbing. Although, and of course, my question is whether this is just character evidence, gee, he likes gory stuff, or whether there's sufficient relevant tie-up here that the person that he initially gets this video from is the person that he shares photographs of the of his dead mother with in very short order after her death. That's starting to indicate to me not a signature identity, but that it is relevant towards the identity of the person
he killed Miss Garcia. Let me hear your thoughts on this motion, please.
Your Honor, there's a lot to unpack, okay? And I think that's part of the problem with the motion. I've spoken to a clearing presentation and I hadn't bear it. I think that, first of all, we need to establish what is the material fact the evidence supports. That's one. And
Hey, I'm sorry, Ms. Balker, it's really identity of this individual. How does he know this individual? What is their relationship? Because I assume the state is going to put into evidence, well, I guess, so if they're going to put into evidence the fact that very shortly after 11 o'clock at night, this fellow CG started receiving phone calls and photographs implicating your client in having killed his mother right there. In other words, they're alleging that he did it and then called this fellow up and sent him photographs of it. His earlier, there may be some relevance to how does he know this guy? What is their earlier interaction? Why? And then a question of why him? Does he? Gotta tell you, I'm like right on this fence. I'm not sure which way to go with it, but I can see that the connection, if you will. I'm sorry to interrupt you.
no, it's okay. I think, Your Honor, I think that, first of all, evidence is being lumped together and really not to separate it, right? To your argument of it establishes identity, I think that the prejudicial nature of this exchange without specificity from the state and without any type of, I think it's propensity at best. I think the fact that the state is discussing the reaction of the children, and to summarize it, if I may, it is the state's position that this defendant gets off on board content. So really the murder is incidental to creating content. What relevance does it have if he actually enjoyed it? In fact, I would say that opens the door for me to then introduce character evidence, perhaps get an expert, perhaps get maybe an esthetician or somebody that gives me the statistics on how many people, how many children have viewed this video, what the reaction to it is. Mr. Borsch classifies it as they reacted normally. What does that mean? There's a lot of different explanations for a flat effect. Forgive my pronunciation. There's a million different explanations of why people respond differently to stimuli. I think that you're going to try to break it down, but I think if we're focusing on the creation of boring content to shock and to gain glory is really the intent, then really the murder is just incidental to a creation of boring content. But ultimately, it's speculative at best. How the state speculated if he actually enjoyed it. I think that's one. I think that will open the door for me to introduce evidence of how he did or he did. Second of all, I think it's entirely irrelevant the children's reaction, which most of them had already seen the video anyway, because I don't think that the reaction goes to any material fact here. What does it matter? Like I said, there's a million explanations why people reacted they separately. And I think that it's also important that the video was sent to him after he's sending photos of his newborn baby sister. That's the response that he gets, okay? In Your Honor,
Why is that important?
Your Honor?
I'm sorry.
Because I think that's really what the state is doing here is that they want to pin him as a depraved, inhumane, insensitive human being. That's really where we're going, right? I get off on gory content.
I call it character evidence.
Okay, character
and that's what 404 is about. You don't bring in prior wrongs, bads, or acts just to show that this is a bad person.
Widmore talks about it as legal relevancy versus logical relevance. But I got it. That's what I was asking before. If he had a prior record, does that come in? No, it doesn't prove the specific element. But the exceptions in 404, I was trying to figure out whether these worked or not, are to prove a material fact in issue, including but not limited to proof of motive. Was it his motive to do this to impress his friend, like exchanging gory stuff, or impress his CG or his other friends? Intent, preparation, plan, opportunity, motive, a knowledge, identity, absence of mistake, or absent, and then the specific statute is
it is inadmissible when the evidence is relevant solely to prove bad character or propensity. And I'm right on the fence on that one.
Judge, I think the one really important issue to highlight with this presentation is that it all focuses on the defendant. Mr. Borsk saying the defendant, meaning there's nothing tied to the mother. Okay, and I think that in order for there to be a clear nexus, or in order for Mr. Borsk to advance, let's say, the theory of motive, there's other evidence, I think, not motive, I'd say it really is the backdrop to this, because what's really happening here is that if Mr. Borsk mentioned full context, and it's not, the case law doesn't say full context. The jury will need to get the full
full context. The last one though, that listed as motions to address today, we make whatever else we want as well for, eh? But it is motion to preclude evidence and argument unsupported defense theory of third-party guilt pursuant to King versus State. And I will tell you, I started this analysis about what concerns of precluding defenses, but then all these cases seem to be very compelling. So I guess I have to start with, and they tell me if you want to do this today or a different part, or if we get to different analysis as a purple. But I'd kind of like to know what it is that you intend to introduce in terms of evidence from the defense that will suggest someone else did this.
I think would cover part of it. Well, first of all, I think that time as to any fear of defense is not appropriate right now. Making us divulge our fear of defense is not appropriate right now. I do see the burden to a certain degree if I'm going to put forward the evidence of a third-party guilt defense. I understand that. I provided Your Honor, within my motion, both with my response pleading and also with the additional authority that I've filed, really the line of, there's two different things, right? A line of questioning of a witness, and then the evidence that I would be seeking to introduce. I think that the lab reports are extremely important in this case. I think the DNA.
One.
There are two lab reports, Your Honor. There's one from April 26th of 2024.
What type of lab report is that?
That should be in your binder.
I'm sorry, I know we've been going for 3 hours, but I still haven't had an opportunity to read through this.
Not interested, Your Honor. It's also in the USB that we provide the UCL.
Oh, I'm sorry. It's because that USB I reviewed very closely last night, and in fact, I have the
Everything that's in the binder, Your Honor, is digital. I was just getting a paper copy.
Oh, the USB that you provided today.
No, sir. I did not provide a USB space.
The USB that you provided on November 30 or sometime in December, I reviewed that last night.
Okay.
It's our Kingston USB.
Yes, sir. If you go to
That's exhibits. Which particular crime scene report do you want to look at?
Your Honor, if you go to your binder, if you're doing it paper form, it's number 17.
That's the lab report showing DNA of third party. I have that right here in my hand. And at best, I could have with you viewing it earlier by asking Mr.
Divorce, what specific item is it that you believe shows that third party? And the old thing I could get out of this in regard to third party DNA was something on the purple knife sheath. Is that, and I gathered that from page 3 of 4 of the forensic DNA report, where it's about 3 paragraphs from the bottom, where it says partial Y STR DNA profile was obtained from exhibit 11.1, swabs from purple knife sheath does not match
the YSTR DNA profile from 10.1 true to all standards from Derek Rosa. Is there something other than that that you're intending to utilize from this report?
Yes, Your Honor. The top of the right foot.
The what then?
The top of the right foot on page page 2 of 4, Your Honor. The first full paragraph.
Right top foot is the third paragraph.
Left hand, my apologies.
All right, a mixture of DNA profiles, 2 contributors, including 1 male, was obtained from 8.1 swabs from right top foot. Major component is that of Irina García. Let's see, the frequency that is unreasonable to be concluded that an unrelated individual would be the source of the DNA profile obtained from 8.1 swabs from right top foot. So they put together this swab. I think that, let me see if I got it right.
If you would like, Your Honor, if it's easier, if Ms. Medina could share the screen and highlight exactly what we're looking at.
Okay, so you know what, this is the point I'm getting to that I think we are going to end up with. The fact that, gee, there's some oddities, and I'm going to state it to that because I'm not really sure that there's anything probative at all for its DNA stuff yet. I'm going to have to determine that once you get a DNA, I guess at the time of trying, as to whether it'd be relevant to this case at all. I wish I'm going to read your DNA deposition. Or it's like, gee, we got this DNA gap here. That's fine. Then I've got a whole USB of photographs of target practice. And things of that nature, which for the life of me, I can't understand why it would be admissible in a case like this. I don't really want to go through each and every one of these right now. I think perhaps we may have to do it during the week of the 5th. But let's start with them. I've got, you sent me all these photographs of like target practice. What's that relevant of?
Your Honor, first of all, I don't think that the photographs are appropriate right now, and I'll say exactly why. The thought process, well, before I say that, Ms. Alau's deposition I checked was, which you were handed a copy of, that took place on the 7th of March. The report from Detective Mui also came in March, but it was after that. So I'd like to be able to also submit other depositions. For example, Mr. Eichenblue, our forensic expert, and
of course, as much as you can get to me that helps me to understand this would be greatly appreciated.
Because that was not discussed. My point is that was not discussed, and by that I mean the codicil was not discussed with Ms. Andar.
Okay, let me go back to the issue that we're dealing with, and that is, you provided me with a disc that showed me a whole bunch of photographs, and as I look through them, I'm wondering what is it that the state has asked me to exclude this, and I'm asking you, why is this photograph that detailed as CSP220, why would it be relevant to our shot?
No. The state is the one that furnished these photographs. I don't think that they're asking for the photographs to be excluded. I think that the theory of third-party guilt, right?
And are you seeking to introduce this photograph? That's a yes or no?
Right now, no.
No, thank you. Now let me go through the rest of it. I've got here are 2 photos of target practice. I've got 2 photos of a computer screen, CSP, taken under MUI's directive.
Are you anticipating seeking to amend those?
No, Your Honor, and just for expediency, again, I don't think that none of the photos which are in your binder, I am seeking to introduce right now.
Okay, got it. Well, that's much easier because, and then the question, of course, I think what the state wants to know is, gee, are you going to be standing up and opening statement and saying, Frank Ramos killed Irina García?
I think it's inappropriate to ask that right now, Your Honor. I think that...
Yeah, I think you're right to a certain degree, which is that you may not know what defense you're going to raise at a trial.
Or put one on.
Or even put on a defense. On the other hand, I understand there's a couple of days worth of testimony that puts Frank Ramos somewhere other than Hialeah. That's the time of the murder. At least that's what I asked him about, or I am learning about from your MCI Express records and some of the depositions that have been provided. And just as an administrator in charge of putting on this case and figuring out what to do with the jury, I kind of like to know how long they're going to be doing this and whether there's going to be an extra 2 or 3 days to address that issue.
And you're ready, Barillas?
Of course, Mr. Borst, I'm not going to preclude anybody from being heard.
I know you'd never do that. I just like to make sure if I heard.
I'm sorry, you just made me hurt my eyes rolling them again. All right, Jonathan, what do you want to tell me?
Yes, Judge. So, under King, okay, and I think the court and the defense and the state all agrees that King is directly on hold. That the defense cannot accuse a third party unless there is a clear link between that person and the crime that was before the jury, okay? Not only is there not a clear link between Frank Ramos and this murder, Frank Ramos is undisputably on video in the state of Georgia at the time. And I've submitted to the board video evidence of Frank Ramos and Guillermo Sevilla in Jacksonville exchanging their trail. I have submitted to the court GPS records showing that his truck traveled up north, state of Florida, into the state of Georgia. And that's exactly where he was at the time that this crime occurred. The cell phone records indisputably show that he was in the state of Georgia at the time of this crime. For the defense to be able to get up an opening statement and accuse Frank Ramos of committing this murder with no supporting evidence whatsoever, that is not lawful under the state of the law. Under King v. State, it is entirely speculative. It is entirely remote. That's the way the law is. And unless the defense can show, Your Honor, which I thought was the purpose of today, for them to show, Your Honor, evidence that would impeach or otherwise call into question the state's assertion, supported by evidence, that Frank Ramos could not have been there. If they can't produce that today, the court should exclude the defense from being able to attack and accuse a man who was nowhere in the vicinity at the time of the crime. They have not provided that, Judge, and that's why you're asking about target practice and photos. That is entirely irrelevant. Today was the day the defense had any evidence to show that Frank Ramos committed this crime to present to the court. They have not, and the state has provided all of the evidence to show that he was in Georgia. So we are asking this court to enter an order precluding the defense from attacking and prosecuting Frank Ramos for a crime he could not have committed, and there is no evidence to suggest otherwise.
Sounds so bad when he says it that way, Mr. Young.
Yeah. There's a whole lot going on. Okay. And I don't know if I can get to the bottom of it just yet. I mean, obviously, it may not be the best tactic for the defense to bring forward a theory of defense or suggestion that someone else did it. When the state suggests, but they can so soundly take that evidence and cram it down to zero, it tends to undercut your credibility in front of a jury, and that happens. So, but that's a decision that you have to make, because I'm not in a hurry to purport a defense. Okay? On the other hand, I've heard it in this courthouse debated when a defense lawyer stands up and says Frank Ramos did this, knowing that they did not. Whether that's a false statement to a tribunal, you know, which is the bar kind of frowns upon. And I actually, at insistence of a judge friend of mine, researched it. I don't find any bar matters that have ever been raised that way. But I would not preclude a defense of, gee, it could have been someone else because you don't have this or this or this. But there's a lot in Mr. Boer's arsenal. You know, there's a hole in this investigation, and the state can't prove that it wasn't this. Defense lawyers make that argument all the time. But to stand up and say, ADC Mr. So-and-so did this with the full knowledge that he didn't, that's what I think Mr. Borst is bringing up. And that's why I asked, what is it that you intend to present of affirmative evidence that someone else killed Miss Garcia, other than the person who called 911 and said they killed her, other than the person who sent photographs of the dead body to their buddy within 7 minutes after the offense, other than the person who sat in front there with the police officers and told them that he did it, other than the person who researched how do you kill somebody with a knife shortly before the murder. What affirmative evidence do you intend to present at this trial that someone else killed Miss Garcia?
Your Honor, as I said, I stand by what I said previously, that the DNA evidence, I think the DNA evidence is very important in this case. I also think that this issue is highly premature, and I don't know what the court entirety means, fully knowing that he didn't. I don't know what that implies. I don't know what that means. I wasn't there.
I don't know, man. I have something that undercuts the validity of what they say they're going to present and have provided to you in GPS location. And you know, when I was reading through the depositions, there was some allusion there that Mr. Ramos called Miss Garcia's cell phone right in that operative period. He says he was alarmed by the ring video or something like that, and he called Miss Garcia to find out what was going on in the apartment. This is what I'm gathering from the discovery. I don't know what you need to present. So I would constantly be actually you'd know exactly where his cell phone was and where her first cell phone was when that call was made. And that would seem to be a piece of evidence, notwithstanding the 2 days worth of other evidence the state would have to present, indicating that a suggestion that Frank Ramos did this might not be in half their reputation. So that's why I'm curious about it, because like I said, I don't want to deprive somebody of an appropriate defense. On the other hand, I want to spend 2 days chasing the tail on something that... Mr. Boersch, here's my problem. I don't want to be fact finder here. I don't want to be the one who says, gee, this evidence definitively shows that Frank Ramos didn't do it. It may fall to a jury.
Well, the issue with that, Judge, is this is exactly what King v. State is for, is that if the court chooses not to enter a pretrial ruling precluding it or excluding it, the state will be objecting every single time the defense ever tries to attack Frank Ramos and prosecute Frank Ramos, because there is no causal connection. And King v. State, that's exactly what King v. State says, is that the trial court sustained the objections from the state when the defense tried to elicit testimony or evidence that someone else did the crime. So if the court doesn't want to make a pretrial ruling, we will immediately object, and we will ask for the court to sustain every single mention of Frank Ramos, because there is no clear connection that the defense has offered that would otherwise undercut. I mean, I could put on video right now, for your honor, Frank Ramos in the state of Georgia doing his trial exchange. You know, today was the day the court asked for solutions to resolve this issue,
It either needs to be resolved now or it needs to be resolved at opening statement. But either way, it has to be resolved, and the state wants to believe that the board will sustain any objections as it relates to Frank Ramos being one committed a crime when we have irrefutable evidence.
The line is up, Boris. Why don't you just put on your irrefutable evidence?
Because the state makes it clear that
The state says it's within the discretion of this court to exclude. It does not require exclusion. It allows the court to do this. And let me point out to you, Ms. Riello, we might want to take a look at Rivet versus State 307 Southern Tier 801, which is on much less evidence in Mr. Boris' patents that the board was sustaining in precluding 404 evidence and evidence against the alternative suspect. And also take a look at Robinson versus State before it's back on November 12, which clearly lays out the burden in there. If you're going to, I think it's in there. Sure, fine. Yeah. An allusion to state which is Serino, which is if the defendant's purpose is to shift suspicion to another person, evidence of past criminal conduct of that person should be of such nature that it would be admissible if that person were on trial for the present offense. And candidly, anything you want to affirmatively present, I'd like to go through ahead of time to determine whether, in fact, it would be admissible under the Serino and Robinson standard that I think is appropriate. That's my question. What affirmative evidence do you intend to produce? I'm going to give it one some more thought. Mr. Boris does make, again, I'm not in a hurry to preclude an offense. On the other hand, it's not really fair to allow you to make allusions that are disingenuous and non-supported by the fact, and leave it open at this point as to what we do, and we'll figure it out before we finish up the week of January 5. Is there anything else that, I'm sorry to not be able to get to the bottom of this claim, Boris, but it's not something that comes up every year.
So I'm just the judge, and I know we provide a lot of assurance from the court review. If there's anything that was like to be published here for the court, I'm more than ready to do it.
We need to do it during the 5th. I will also say one other case you want to look at. Ms. Riello was Bowen versus State, which came out of this courthouse. Tried before Judge Frederica Smith. It'd be tough to find a more competent judge than she was, where the allusion to another suspect was precluded in that file and sustained by the 3rd District. And we'll take a look at that.
So one of the authorities that I supplement, the only other thing that I would say, much like I did on the other motions of Your Honor, I would guide Your Honor to the supplemental table of authorities that I provided today on all 3. And just specifically, excuse me, Ms. Morales, specifically the King motion, please.
I will have full opportunity to see those before the 5th. Anything else that either party wants?
Yeah, so just on that note, I see a voluminous binder, and we had a lot of references to FAs that were provided to her this morning. The state wasn't shown anything provided to beforehand, nor will they provided one, so I have no idea exactly what it is Your Honor's been reviewing or the defense keeps alluding to, so I don't know if I'm very able to provide a copy to the state.
You're not terribly prejudiced because I didn't get a chance to review what was paid to me after I walked into court. However, what it is, you take a look at, and we can certainly provide you with that, the index indicates what's in there, and it appears to be all the materials that have previously been filed with, including one that just filed, which would have been the supplemental authority with the
The list of cases that they
Yes.
okay.
Yes. If you want, you're welcome to take a look at the binder that I have right here to determine there's something in there that you go about.
Thank you, Judge. I would like to take that opportunity to move that.
And any other substantive matters that either party wishes to address for today?
Oh, my God, please.
Are we going to see new counsel in this case?
The behind.
I mean, I don't mean new, but I mean new in the sense of additional. Okay.
Nothing further from the defense.
Not hearing anything now. All right. Okay. Is there any I hear you from nothing further from the defense, but I want to expressly give you as much opportunity and a final opportunity at this point to address any matters that you believe are appropriate for you to address in the context of this case at this time, Ms. Rio. And you're welcome to consult with your client before you decide what you want to address, Nicole.
I consulted with them during our breakdown. Thank you.
Okay. Anything from this date?
Yes,
Okay. I imagine prior to the 5th, I'll send you all out an email that outlines the areas that we're going to be addressing. I'm thinking we may need a closed session because I'm going to need to discuss the logistics of how a jury can get picked in this case and management of that jury during jury trial. And if we do that, we'll do it early and do the court recorder in chairs. And that's just an objection to that. Okay, if there's nothing further, thank you all very much. I hope I didn't miss anything. You see?
Does she want us to keep January 6th in mind and we're not?
Oh my goodness, we're going till we are done.
Okay, we're going to, we're done.
And then how long do you think it would take you to put on all the evidence on it? Because
I'd have to think on that, but given that we may have additional evidence on some of the motions from today.
yeah,
And some.
I think those are going to 6.
Okay.
Okay. Another now, I assume we're going to get to hear from Dr. Sperry.
On the 5th, yes, sir.
Yeah.
Do you require her actually? Thank you for live. Do you require her live, or can she appear via Zoom?
I'm going to ask the state what their feeling is about that.
Just 1 second, George.
Well, Mr. Bohr says he doesn't have an objection.
No, I certainly don't. I see that matter as more your rights gun states when it comes to confrontation and not perfectly. I'm totally word reading the deposition, I must say. And wrote a lot from it.
There. Both cards, Judge, or just the first?
You know, I only read the first part. Can somebody provide me the second part?
Gorgeous, right? Well, I don't think we've received it yet, but we did at great expense order it rush, so I can check on that. And if we have it, do you want it brought to Honor's Chambers?
You'll send to me electron, the fine.
Just because it would be a PDF, and I know you just mentioned you have issues, would be some PDFs.
Some of them I do, and if I do, I'll let you know. The transcript should be from across okay. During the week of the 5th, we're also going to address a lineup of witnesses as to what the state intends to present. We order witnesses so that, like a federal trial, where you learn about,
You get your James material at the beginning of the case. And I'll tell you, I promise not to be as restricted as Judge Sloan.